We'd love to see your videos, so if you could turn them on during the webinar, just so that we could interact with you at some point, that would be great. So while we wait for a few more people, I thought I would randomly cold call a couple of you and just ask you to introduce yourself, tell us a little bit about why you're here, where you're from, things like that. So I'll start. My name is Vivek. I'm currently in Bangalore. I'm 22 years old and in my final year of law school. So I'm going to tag one person. And as soon as you finish introducing yourself, just pick out a name that you see and that person will have to go. So I pick Samved Ishwar.
Hi, I'm Samved. I'm currently living in the UAE right now. And I'm a first year student at Nalsar. Super excited to learn with you guys. Yeah, I pick Samriddhi.
Hi everybody, I'm Samriddhi and currently I'm living in Bangalore. I'm a first year student at Nalsar. I'm super excited to learn how mediation works. I pick Priyasha next.
Hi, my name is Priyasha. I'm 19. Can you all hear me? Hello?
Yes, we can hear you.
Sorry, like this thing popped up saying that my internet was unstable. Anyways, I stay in Bangalore and I'm excited to learn more about mediation and negotiation. I pick Kiara.
Hi, everybody. I'm Kiara. I'm from Mumbai and I'm in my first year as well. I'm 19 and I'm super excited to be here. I pick Archita.
Hi everyone, I'm Archita. I'm from Bangalore as well, and I'm a first year law student at Nalsar. And I'm very excited to find out more about mediation and the process and the competitions and stuff. I pick Chetna.
Oh, hi everyone. I'm Chetna and I'm from Bangalore. I'm a first year student at Nalsar and I'm totally looking forward to this course in mediation. I pick Barka.
Good evening, everyone. I'm Barkha Singh, and I'm resided presently in Hyderabad. I'm a first-year student, and I am so excited about this mediation workshop that we'll be attending. I hope it all goes amazing, and I think it will. Thank you. And I pick. Okay, 1 second. I pick. Isha. Same.
Hi everyone, I'm a second year law student from GLC Mumbai. I'm very excited to be here, looking forward to learning from everyone. I pick Charul.
Hello everyone, I'm second year law student from NMIS Indore and I'm really very excited to learn about mediation and learn from you all. So yeah, and I pick Sanskriti, if she didn't go. Thank you.
Hello everyone, I'm Sanskriti Saraf. I'm also a second year law student at Government Law College, Mumbai, and I've participated in mediation competitions, but I'm looking forward to learning the tricks behind it. So yeah, I'll pick Mudit if he hasn't already spoken.
Thank you so much. I hope I'm audible. Yeah. Hello, everybody. My name is Mudit, and I'm a third-year law student from National Law University, Nagpur, and I live in Dehradun. And I am very passionate about the field of mediation ever since I found out about it in my first year. And I hope to meet more like-minded people like you all, and I hope we can all learn new stuff here. And like anybody else who wants to introduce themselves can go ahead, because I think everybody who turned their videos on has already spoken.
With that, actually, I think we're going to have to cut the introductions a little short. We would like to keep things on schedule. So today is actually going to be a pretty easy day. It's just an introductory kind of session, and we thought we'd ease you into the course. And tomorrow will be a little bit more rigorous, and you'll have to pay attention, and there's a lot more homework and stuff for tomorrow. Today is a little bit easy, so I'll start off by sharing my screen. If at any point of time I'm not audible, or if you have any kind of issues, you can always unmute yourself or just put something in the chat box, and we'll immediately get to you. Okay, yeah, so sharing the screen. So a little bit about Swinny and myself. So I'll start really quickly, and then Swinny will talk about her. I started doing mediation competitions in 2018. So the first international mediation competition that I did was YIMC, which was in Hong Kong, the Young International Mediation Competition. So that's sort of when I realized that mediation is not just about how you negotiate or what you walk away with from the table. It's a lot more about collaborating with people, showing that you're capable of coming up with a creative solution that isn't in front of you, and really taking the time to step back, look at what the issues are, and try to find a creative way to work around the conflict that you have. A couple other competitions that I did were Advocate Maximus, which was an arbitration and a mediation competition. So luckily we won that one. I also went to ICC, where I placed 10th out of 66 teams. So we were the only Indian team that advanced as far as we did. I've also won second place at Warsaw negotiation round, and I will be participating in CDRC a little later this year. Swinny, are you there?
Yes, hi. Just a quick note. I guess there are some people in the waiting room, if you could let them in.
Oh, yeah.
All right, so I will introduce myself. Hi, everyone. I am Sweeney. I'm so happy that all of you are joining us today and this entire week for the mediation course. A little bit about me. I am currently in my 5th year in Nalsar University of Law, and I see there are a lot of Nalsar students who are currently in their 1st year, so hello to you as well. I started off in the ADR field quite early. To be honest, I started off in the mooting field in my 1st year itself. I participated in an international maritime law and arbitration moot. So as you will find out later on in the course, that arbitration also comes under the ADR format, which is alternative dispute resolution. But the way it is scheduled is under the mooting format, which is kind of dispute resolution by contesting. So I started off my first moot itself, which was an international moot in arbitration, and I performed quite well. We went to quarterfinals, and that gave me the encouragement to explore the arbitration field a little bit more. And then I went on to participate in Wiz East, which is organized in Hong Kong, and I believe that was in 2017 or 2018, I guess, 2018. And it was quite an amazing experience. It was again about commercial arbitration, and I met a lot of arbitrators there, and somehow I got into the mediation side of ADR as well. And that's when I started exploring mediation and negotiation competitions. I then participated in CDRC Vienna, which Vivek will be going to this year. And that was again in 2019. And we had a really great experience over there. And I wanted to explore the field a little bit more, and I participated in 2020 in ICC Asia Pacific mediation competition, which is APCMC. And it was such a great experience that I really wanted to continue further. And all the knowledge I gathered about ADR, I felt that this would be a great opportunity to pass it on to newer students who are entering the field and also want to explore ADR in their very early years. And I believe we also have some students who are in their third and fourth year who I think might be well versed with the concept, but we're very happy to share the information of Vivek and I, whatever we have gathered from our experiences and whatever we've learned over the years. And even we've also taken up a lot of ADR courses during our time at NALSAR. So I believe that this session will be really, really helpful to you guys in getting a very comprehensive view of how to approach competitions. You will normally get a lot of different mediation workshops for actual sessions, but this is designed specifically on how to approach competitions, and our experiences might help you a bit. So Vivek, over to you.
Thanks. So next, I think Swini's going to talk a little bit about the structure of the actual course and what we're going to be doing over the next few days.
Why does he have such an accent?
Right. So the structure. So to start off, we wanted to make sure that you had a good idea of how mediation competitions work, and then also try to give you practical aspects of it and how to actually go about it. So the first part, what we're going to do in the first 3 days, which is today, tomorrow, and day after, we will be teaching you and we will be giving you all different kinds of instructions, talking about the different aspects of mediation, going into the preparation, how to identify your positions, interests, and everything which you should normally do before you go into your mediation competition. And then we will, on day after tomorrow, we will be teaching you what happens in an actual mediation session. So what do you do at the table? So we will be covering these 3 days in just proper instruction and getting you prepared for what's to come. To make sure that you also understand that normally you read books on mediation and negotiation, and you never really get to apply it, and unless you participate in different competitions. And when you go into competitions, you're kind of blind and you don't know what to do. So what we are going to do in our 3 days of instruction is we will be having an in-class problem, which I believe has already been sent to you today, earlier this morning, or for everybody on YouTube, we sent it to you this evening. So we will be breaking down that problem. We hope that you read the problem and come to class tomorrow. So we will try to understand the problem, try to understand the different aspects which you need to prepare on before you walk into the mediation session, and how you will be using this information in the session as well. So this will actually kind of give you an understanding not only of the theory, which you will be easily be able to access everywhere on the internet, but also a practical application of that theory in a problem of how it is usually drafted in a mediation competition. And it will be slightly rigorous from tomorrow onwards. We will be having some take-home assignments as well. You will have the time to do all of them. And in those take-home assignments, as I mentioned in the email as well, that you will be having another problem which you try to solve. So we will not be asking you too many theory questions, because I feel being a competition workshop, you should be able to try and analyze the problem better and try to brush up your skills on how to perform in an actual session. So we will be testing you more on application-based questions, which is how a lot of the exams are also there in NALSAR. So they will be quite a little bit tough, but as long as you pay attention in class, I think you should be able to do it. And please make sure you finish those assignments in order for us to give you your certificates as soon as possible. And then comes the more interesting part, which I'm very excited about, is part 2, which will be the 4th day of this week-long workshop, which is the panel discussion. Now, to give you an idea and also a contrast between what happens in a competition versus what happens in an actual in real life mediation sessions, we are inviting three experts from the field. Dr. Andrea, we have Mr. Jonathan Rodriguez of PACT, who is the founder of PACT, and also Ms. Purvi Satija, who is a former alumnus of Nalsar University from and also graduated from Harvard, and also is currently working at White and Case. So they're really well known in the field, and you will always somehow or the other meet them if you're venturing into the ADR competition circle. And it's really great to develop connections with them. So also on the panel discussion, we will be having our youngest member, who will be Mr. Yashasvi Raj. He's also a student at Nalsar, but he has participated in so many mediation competitions, and we believe that his experience will be very helpful to you guys in understanding how to look at it from a participant's perspective, and also how to look at it from a judge's perspective when you interact with the experts. So we are trying to give you best of everything as much as possible. And I hope you use this opportunity of panel discussion as a very good networking opportunity, and try to interact with them. And I hope the same will help you in the future, not only with the experts and the three students from Nalsar who are taking this course, two students from Nalsar who are taking this course, but also everybody present in this particular Zoom room, whoever is participating, interacting, connecting on LinkedIn will really help you guys. So it's a great networking opportunity. And lastly is the finale, which I guess is the most exciting part of the course, is the practice mediation session. So as most of the attendees on the Zoom might have received an email from me earlier this morning that you will be having a test problem on which you will be having a practice session, and you have been allocated into different roles of client, counsel, mediator, and you will be using everything we taught you in these 3-4 days of the workshop in the actual session. And we will actually be judging you on the same. We have a lot of experienced mooters from who are our friends and networks which we have developed over the years, who will be judging these rounds. I'm sorry. And the surprise is that there are 3 prizes there. So it's best if you, I'm so sorry, my voice is gone. But you should try to take it seriously and work for it as hard as you can. You have your email IDs of your teammates whom you can work with, and also try to win the prizes. So over to you, Vivek. I'm so sorry.
So one thing that I just wanted to add quickly is that people have been allocated their roles as either negotiator or mediator. Don't worry in the sense, don't feel like you're not going to get the entire experience. The way we've built the tests is to ensure that you're going to have to make an opening statement for mediator as well as a negotiator. You will definitely have that holistic experience and not just be focusing on the one role that's been allotted to you. So these are just some of the popular competitions that I thought you guys should keep your eye open for when you guys do finish this workshop and actually start participating. So the main reason these workshops are held, obviously, to give you that kind of introduction into the whole ADR world, sort of teach you or test you on the skills that are required for you to be a good mediator or a negotiator. But it's also an excellent networking opportunity, as Swinny said multiple number of times. Some of the internships that I've done have come because of the people that I've met here. I've been part of a research assignment because of someone that I met at ICC Paris. So essentially, there are a lot of different things that come out of participating in these competitions, other than just you being able to advance your skills or show off your skills in the winning sense. But I feel like it's really important for all of you to appreciate that there are these different reasons for the competition to be held, and really immerse yourself in the process and not just focus on the winning aspect, but all of the other aspects that are involved in the competition. So what's expected of you in general from these places? It depends. Either you'll have some kind of system within your university where you need to go through a selection round, and then you'll be given a ranking, and based on that, you'll be allotted competition. That's specific to different universities. A lot of these competitions also open up the applications. You can just apply directly to their website. You don't need to go through a university. It's an open challenge sort of thing. And you may need to submit your CV, you may need to submit a statement of purpose. It depends on every other competition. So in terms of how this would benefit your career, like I said earlier, research assistant positions, internships, all of these things are added plus points, but it's a great add-on to have in your CV itself, saying that you participated, you excelled to this particular level, or you won, like you placed first, second, third. These kinds of things show that you have put in an effort to build your extracurriculars on your CV and to actually get out there and not just focus on the academic parts of law school. Now, these are some of the most popular competitions. On the left side, you can see all of the international ones, and on the right side, you can see all of the domestic ones. If you have any questions about this, feel free to reach out to either of us, and we can either answer them or put you in touch with the right people, because we do know a lot of the people that conduct these competitions. So if in this part, the part that I've just showed up on the screen, these are different segments of a score sheet that you would have to, that you would be graded on if you were a client or counsel, essentially if you were a negotiator. So you need to have a bang-on opening statement that clearly describes the facts of the case, that shows why you're at the table, what you're hoping to achieve by being in this mediation. Of course, we're going to go through this in more detail throughout the course. You need to make sure that you continuously advance your interests, but you do it in a manner that you're not making the other party seem as if they're being attacked, or you need to make sure that you're doing it in an appropriate way, which of course we're going to talk about later on in the course. Teamwork, making sure that the role between the client and the counsel is very clearly divided. You need to showcase that you have a game plan and that you both have showed up to the table with particular roles in mind. You need to ensure that throughout the course, you are asking different questions. What does the other party have to hide from you? Or why is the other party there? How can I help the other party to ensure that we both get some kind of amicable deal here? So that's information gathering. You need to show that you're willing to work with the other side in order to come up with creative solutions, and they grade you on that, and that's the collaboration segment. Now, developing options is essentially creating some kind of amicable and a unique solution that may not be something that stares at you in the face, and also churning out many different options so that there's a variety of different things that you and the other party can work with. So developing options is twofold. It's the creative and the uniqueness of the option, as well as the volume or the number of options that you create. Now, use of the mediator, the whole point of the mediation is to have this third party, this unbiased person, to help you navigate through the conversation. Now, in real life, of course, the mediator is going to do their job on their own, but in a competition, it's not always guaranteed that the mediator knows when to intervene, because he's just or she's just another student like you. So it makes sense for you to use the mediator on your own. Keep talking to the mediator, keep bringing them in, and you get scored on that. Whether you ask the mediator to list different things and actually set an agenda, whether you ask the mediator to use the whiteboard so that you have a visual representation of what's being spoken about. These are things that really help get you points on a score sheet. Now, everything that's showing up on the right side now has to do with the different points that come up on a mediator score sheet. So here you need to ensure that you create the good qualities of a mediator, creating a good atmosphere, making everybody feel comfortable. Basic things like this, they would have different points allocated to each type of quality for a good mediator. And this varies from score sheet to score sheet. And we'll talk about a couple of score sheets so that you get a better idea of what we're talking about here. Now, effective communication skills, that could be your opening statement. It could mean that you have to maintain a positive and neutral language throughout. It could also mean that you diffuse conflict in a very unique way or in an effective way. So these are just three of many possible points that could come under effective communication skills. Now, effective problem-solving support would probably be something like asking timely questions or focusing on what in the dispute is linking or is linked to the party's interests. Bringing people back to focus on what really matters, encouraging creative options without showing any kind of bias, and every now and then maybe checking in with reality, seeing how much progress have you made in the mediation, where do you think you're headed, sort of emphasizing or clarifying these points throughout the mediation would fall under effective problem solving support, because as a mediator there, you're supposed to be their crutch. Now, the mediation session process, this is pretty broad, and there are going to be a lot of subpoints under this on any good score sheet, and they'd have to do with making sure that you have a clear agenda for the entire thing, demonstrating that you're controlling the conversation and not being controlled by the parties. If either party shows aggression, you being able to calm them down and bring them back to the whole collaborative process and ensuring that they follow the tenets of mediation. These are the kind of things that would fall under this particular section. Essentially, it's the overall management of the process and whether or not you're successful in doing a good job. Now, the caucus is a really important part of most of these competitions because they care about you being able to maintain confidentiality. Now, it's difficult for you to show that you care about confidentiality when it's a group conversation, which is why they want you to have a caucus where you can take this confidential information and turn it into a creative solution. And if you're able to do that, then your points under this whole caucus segment will increase for sure. We'll, of course, talk more about each of these points later on. If you have any questions, then you're more than welcome to put them in the chat box or just unmute yourself and ask away.
So I had a question.
Sure.
I would like to know more about effective problem solving support, as in how is the my understanding of a mediator is that he or she weighs in and solves the dispute. So what do we mean by that? And what is the info gathering on the left side?
Okay, so I'm going to tackle your second question first because it's a little easier. Info gathering is just asking different questions so that you get a better understanding of the situation. So if party A has 1, 2, 3, 4, 5 interests, but they're not talking about 4 and 5 for specific reasons, you could ask different questions in order to get them to talk about it. Let's say they have some kind of preferences that they want, but they're not making those preferences clear. You ask, so which one would you prefer, this one or this one? So the reason info gathering is so important is because there are going to be specific points on each of your confidential informations, right, that you receive maybe an hour before the round. Now, by asking the right questions, you'll be able to draw out all of this confidential information into the round. So it becomes general information at this point. If you do make these things confidential to general, then you get more points. That's the basic understanding here. Now, with your second question, effective problem-solving support, a mediator is supposed to be unbiased, meaning that they cannot seem to favor either party. So if they do make some kind of comments with regards to how they feel about the situation or the conflict, it could go either way. So that's something that generally mediators are asked not to do. Do not give your personal opinion, but give them support. Tell them that, you know, in the industry, common practice when disputes occur like this would be to go in this manner, or would be to approach the conflict in this manner. Do you think something like that can be done in this situation? Opposing your opinions or your suggestions in the form of a question would, you know, make it effective support, if that makes sense. Does that sort of answer your question?
Yeah, sorry, it does. Thank you.
Okay, cool. Is there anyone else? All right, so I don't see anything in the chat either. So we're going to talk a little bit about the basics of mediation. So what is mediation? Like just a standard definition, it's a structured interactive process where an impartial third party assists disputing parties in resolving conflict through the use of specialized communication and negotiation techniques. So, everyone is encouraged to participate in the process. You can't really keep quiet during a mediation. You have to speak. And I really want to highlight at this point, because a lot of you are first years, that there is a difference between mediation, negotiation, and arbitration. Yes, they all do fall under the realm of alternate dispute resolution, but when you're in a negotiation, it is just you and another party. You do not have a third party that assists in the negotiation process. When you're in an arbitration, it is essentially a private court where you appoint an arbitrator or a judge to preside over your dispute. Now, the key thing here is the choice factor. Not only are you electing to use the process of arbitration, you're also choosing who is going to be your arbitrator. Now, mediation in this case is an elective process as well. You are choosing to be part of that process, and you choose a third party who is going to help you work through that conversation. It's not someone who presides over it or who makes any decisions. It's just someone who is an unbiased third party that helps you go through a conversation a little bit or a negotiation more easily. So when do we negotiate? It's important to understand that mediation can occur because it's included in a dispute resolution clause in a contract, which means that if a dispute occurs between two parties who have entered into a contract previously, that contract may state that in the occurrence of a dispute, you must go to mediation before you go to arbitration or a court or anything else. So at that point of time, a mediation may occur. Now, mediations could also occur because two parties feel that they don't want to go through the hassle of filing a lawsuit because it costs you money, it costs you time. So it could be a voluntary process that occurs after a dispute has risen. Why do we mediate? Like I said, going to court is time consuming. It takes up a lot of resources, so we like to avoid that. But there are a lot of different disputes that you could actually come to some kind of middle ground with by mediating, where you don't need to burn bridges by filing lawsuits or go through that whole adversarial process. Now, examples of this could be commercial disputes. We see them happening every day, between oil companies and their distributors, or small disputes like between a vendor and some kind of manufacturer. We also see mediation being used between families, whether it's divorce or a partition case or anything like that. Mediation can be very, very useful. So Swinny is going to talk a little bit about where we mediate, and she'll move on from that point.
Thank you. So where do we mediate? So as you might have gotten an idea by now, that mediation is a process which happens outside of the court. Now, which doesn't necessarily mean that it should always be outside the court. So sometimes what happens is that you might have an agreement. Most of the times it happens in commercial settings, as Vivek said, that you might have an agreement which says that if you have any dispute, you must mediate before going to the court. And if you file a litigation before mediation, the court might mandate that particular dispute to go through the process of mediation. And that is usually the court mandated mediation which happens. And in that scenario, the court appoints the mediators. That can happen in the courthouse itself, or depending on what is the circumstance, the mediators can pick a place. So normally it's a situation where the parties come to a consensus as to where do they actually want to mediate. When it is not a court mandated mediation, there is sometimes an idea of going to institutions. So normally most mediation clauses have something like that. They will be following the ICC mediation rules or the IIAM mediation rules, or the rules which is there in India. So depending on that, or you may choose to go to a particular institute. Now, that particular institute might, facilitate this entire process. They might give you everything you need for a mediation, a room, if you want to do it in the institute, and they can also go up to appointing the mediators for you. So that is how most of the mediations function. A lot of these institutes are like SIMC, which is Singapore International Mediation Center. You have the ICC also having certain rules for the same. You have CAMCCBC, which is for Brazil and Canada, if I'm not wrong. ACDC for Australia, WIAC for Vienna. You have many of these international and national institutions, which you can approach for your disputes and for resolving them. Otherwise, you can also have an internal mediation session within your own company to make sure that the word doesn't go out, because that's a main component of any mediation, which is confidentiality. Most of the times you go through mediation because you do not want the word to spread that so-and-so case has been filed against so-and-so in the court, and what is the result going to be? And there are some matters which you might as well just keep private within your company and just solve it like that. So that's how we normally go about the mediation process. And the next question you see on screen is who mediates? So the answer is simple, the mediator. But as I mentioned earlier, that the mediator might be appointed by the court. You may normally, under the rules in India, you can appoint a single mediator with consensus by nomination and by talking to the other party regarding the same. And normally the role of a mediator in a mediation, as Vivek had earlier mentioned, was facilitative. Being a facilitator in ensuring an effective communication and an effective conversation, which most of the scenarios, it's not possible between parties because they're always so at loggerheads before coming to the mediation session. There's some dispute and the conversation has broken down, which is why you need a third party to facilitate the process and make sure that you come to some agreement over there by just facilitating a conversation. And sometimes, depending on if you have chosen such form of mediation, there can be an evaluative mediation wherein the mediator can take the role of playing an evaluator. They can make recommendations, suggestions based on the facts of the scenario or based, but that in competition perspective, mostly you have facilitative mediation. Very rarely you have evaluative mediation, but that's again a process which happens in the real world. Also for mediators, they do not necessarily have to be lawyers. You can pick mediators based on your convenience. Say you have a dispute in the maritime industry or in a construction business, and you cannot have somebody, an IP lawyer, mediating such a session because the issues involved are so complicated that if anybody is facilitating the mediation, they might as well understand the different aspects and concerns which go into this particular mediation of every party. So mostly, you will see mediators in different competitions who may not necessarily be lawyers, but they are very well-renowned experts in the field they usually mediate upon. So also in a mediation, you have who represents the parties. You have the client and a counsel. So that is a normal setting of mediation competition, which we're speaking of, that you have a client who's representing a certain company who is a party to the dispute, or the client may themselves be the person who is disputing with the other party. So the client is again represented by a counsel. So that's a 2-member team which is normally formed and from each side. And the counsel also plays an advisory role in the mediation session. And in real life mediation also, you have a client and a counsel, but there may be a situation where the client is represented by 2 people, but that depends on the situation and what the rules say or what your agreement says before that. You may not necessarily have an agreement before going to mediation, but usually you do come to some sort of consensus before you apply for mediation. And the last question is, how do we mediate? Now, that is the main question which we will be addressing for the rest of our course, which is, what is the process? How is the structure of any mediation that comes along? So we have tried to since it's an introductory session, you might as well just get an idea of how a mediation session in a competition flows. So there are normally 6 phases to the same. The first is the preparatory phase, which is before you walk into your mediation session, the oral rounds or the competition, you have to prepare by yourself with your teammates. That's where you read your problem, you look at your confidential information, and then you break it down and understand the different interests, your positions. What do you want to get out of this mediation? What is your goal? What do you seek out of it? And then you also start making assumptions about why do you think the other party has even agreed to come to this mediation, and what do you think the other party has in mind, or what are the problems the other party is facing. And you start making assumptions, do your research or based on what kind of problem it is. If it is a commercial problem, you might as well just understand a little bit about the field you will be talking about in that session. And that's the entire preparation. And in that comes also the mediation plan, or you may call it the position paper, which you submit to the mediator. And also the judges in a competition. But in an actual mediation setting in real life, you always have a mediation or a position paper which you submit to the mediator, who gets an idea of what is actually the dispute and tries to understand the concerns of both the parties. But that, again, confidentiality being the most important aspect of mediation, will remain confidential only with the mediator. And once you have prepared and you've submitted your mediation plan and you've understood what is your position and why you're going to the mediation for your client, you go to the next phase, which is walking into the actual session at the mediation table, which is the introductory phase. So once you go in, the mediator tries to, you walk in, and there's usually, in real life situations, you will have a lot of tension going around because both the parties have failed to make conversation prior to the session. And the mediator tries to cool down everybody and tries to introduce himself and says that what will be the mediator's role in this session, and will ask the parties to introduce themselves. So that is, you will make a very quick introduction about yourself, that, hi, my name is Sweeney Khara. I am representing the company Lumos in this dispute, and I have with me my counsel, Mr. Vivek Krishnaswamy, who is going to be in his advisory capacity today. And then you also confirm, the mediator will ask you to confirm that if you have the authority to represent your client or make decisions on anybody's behalf or for yourself in that particular session. And that is important because if you do not have the authority, then the mediation is kind of pointless, because at the end of it, you do have to come to an agreement. So that is the introductory phase. And the mediator, in their mediator's opening statement, tries to lay down some housekeeping rules, some ground rules, like please feel free to take a break when you want, or you can call for a caucus anytime like you want. We will be ensuring that the mediator is impartial and neutral, and will keep everything confidential to whatever is said in the mediation. And whatever is said in the mediation is also not used in court anytime after the mediation as well. So all those kind of disclaimers, it was assumed that the parties do not know anything about what is the mediation process. Even if you have done mediation competitions 100 times in your life, they will make this assumption and they will lay down. And you also get marked upon this opening statement as a mediator in competitions. And once all the introductions are done, you've confirmed your authority and the mediator has made people feel comfortable, you move on to the next phase. Vivek, yes, which is the understanding phase. So that has the information gathering phase, which Vivek just clarified in the previous slide. But before you go into information gathering, what you do is you make your opening statements. So the introductory phase had the opening statement of the mediator. Then the mediator asks the parties to express how they see the situation to make their opening statements. So this phase starts usually with the requesting party's client, who describes the situation, gives a short summary of facts, and expresses how they see the problem, and tries to express what they want from this mediation and what they expect from the other party. And then after the client goes a counsel for the requesting party, who states that they will be in an advisory capacity. If there are any legalities to be considered, that those will be addressed in the session in the very beginning. And what they normally try to say is that to stray away from legal aspects, because you might as well have gone to arbitration or litigation if you wanted to fight legally. but fight, not legally, it is legal, but fight on legal arguments. But for a mediation process, you try to stick to more of the merits of the case, wherein you talk about what are your interests and what do you want. You talk business, basically. So that is what the counsels and the clients do. And then it is followed by the opening statements by the responding party. Well, the client goes first and then the counsel. And after everything is set on the table, the first, the first impression of the issues from both the parties, the mediator tries to then say, thank you for your opening statement, and says, let me just summarize what I heard and what are your concerns from both the parties. And they try to just drop a very quick 1-line, 2-line summary of what everybody has said so far. And then you go to the process of setting the agenda. So once you set down the agenda for 2 or 3 points, which you want to cover in this session for 1 hour. So once you set the agenda, that's when you go, this is the entire understanding phase. That's the mediator writes down the agenda on a board or in the chat box now that everything is online. And the parties agree, they have to confirm that they agree to this agenda being discussed in that mediation. And once that has happened, you go into the information gathering stage. That's when everybody's trying to understand, as Vivek said, that why didn't you not talk about point 5 and 6? Let's talk about that. Why are you refraining from talking about that? Let's try to get more information. What is your concern? What is the underlying interest of you not giving me $200? So anything like that. So that's the information gathering phase. And that's when you understand the positions and the interests of yourself and also the other party. And after you finish that session and you get a good idea, the mediator and the parties get a good idea of what is happening, you move on to the next stage, which is the generation of options. So that's when you try to get different kinds of solutions on the table. You try to think and brainstorm different ideas and ask the parties of, oh, what do you think about this? How can we solve this issue in what manner? And you look at more of interest and try to develop as many different options as possible to ensure that at the end of the day, you do not have to go to litigation. And that's when you come up with different solutions. And then there's the stage of agreement, which is the agreement phase. Now, I believe the agreement phase and generation of options go hand in hand. So while you're going through the agenda, so say, let's talk about agenda 1, which is the financial matters. Let's see how much money can you return me because you haven't paid me so much money. Then you try creating options that, okay, we can prepare a timeline, something like that. But at the same time, you start agreeing to different things. So they go hand in hand. You agree to different aspects while you're discussing different options, and you move along the different agendas, agenda 1, agenda 2, agenda 3, and you might again come back to agenda 1. It's kind of a mixture, but you have to see where the mediation takes you. And that's when you actually try and use the mediator to continuously recapitulate what has been discussed, try to summarize what has been agreed upon and whether that agreement has changed in the conversation or not. So then you finally start getting to the very specifics of these options as to what is the very figures and numbers, and solidify that whatever has been talked about is clarified and you're agreeing upon the same things. There's a meeting of minds which is happening, and there's no difference of understanding. And then once you have agreement on different aspects of the mediation agendas.
Swati, we actually have a question from someone named Anjali Agarwal. She wants to know what would happen if the parties do not agree with an agenda.
They try to rephrase the agenda, and normally most parties agree to the particular agenda. Then they try to, if there's an agenda which is not to be discussed in that particular session, they set it off for any other future mediation session which you can talk about in, and also you rephrase it or maybe try to put it under a different head altogether and say maybe we can use it as a sub agenda of a much larger problem. Say if you're talking about getting into a future venture or something, you can have different smaller agendas under it. So most of the times parties do agree to it. If not, then they try to avoid the same and come back to it much later in the session and see if there can be any agreement upon. But competition perspective, mostly you will find the same agendas being set, or maybe just phrased in a different manner, or put it into sub agendas. So that's how it normally goes. I hope that answers your question.
And just to quickly add to that, it's important for you to understand the purpose behind the agenda. You want to make sure that you're talking about different points at the right time. So your interests need to be, organized in a manner where the conversation is flowing. Let's say that you need to blame someone for something. So by blaming that person in topic A of the agenda, you're able to flow quickly into topic B, which talks about compensation. That was a pretty bad example, but I hope you get where I'm going in terms of being able to prioritize things, and that being a strategy itself in your competition.
Yes, I completely agree with that. And I hope we can go probably explore that a little bit more in the future sessions tomorrow and day after. And once you have agreed on those different aspects of different options and proposals and ideas which were put forth on the table by the parties, you go into the final concluding phase. Now, this phase is very important from a competition perspective because you do get graded on it. The thing is that the last 5 to 6 or at least 7-8 minutes you should keep to summarize everything, to make sure that you are on the same page as everybody. Usually the councils take up the job of summarizing everything has been discussed, and then it's a normal flowery language which people use, is that we will leave it to the councils to draft up the settlement agreement. In competitions, you do not have to draft up the settlement agreement. It's just a thing you say, but it's the process which matters more. And in terms of scoring, it's not absolutely necessary for you to reach an agreement on every aspect and get to a final settlement agreement. It's the process which matters more. It's the steps, how you conducted yourself, how did you try to go about different impasses, how did you go about different blocks which you faced in the mediation. That's what matters more. And if you agree on few things and not some, then you can say in the end that, okay, how about we leave this to a future meeting and we can come back to it and discuss the specifics on that. And the mediator usually steps in again at this point and tries to conclude and thank everybody for coming to the session and try to make sure that the relationships are maintained, even if things got heated in between, and summarize and conclude finally that, okay, we are done for the session. And if there's anything else which needs to be said, we can do it in the future, and how to go about drafting the settlement agreement or whatever, the next steps which you talk about. So that's how a typical mediation session goes. In a competition, it's normally 1 hour long, or depending on the rules, it may be longer or shorter. And in actual mediation sessions, that may go up to an entire afternoon, but we will be focusing on the competition here. So that's the entire process. And now we will be going into the different aspects of mediation, which I believe Vivek will be able to explain better. Vivek?
So we feel like these are probably the 7 concepts or the key terms that you need to focus on while you're embodying these parties or these mediators. So the first one would be interest. Now, to define an interest, it's a position that is demanded by a particular party, but an interest is why a party holds that position, if that makes sense. So your position would probably be where you're coming from, and your interest is why you are coming from that point and what you are going to gain from what you're looking for. Of course, we're going to explain that a little bit more in detail with examples. For me personally, understanding interest-based negotiation and positional negotiation has always been a bit of a challenge. So that's why when you talk about positional bargaining, it's considered to be something rigid, whereas interest-based negotiation is a little bit more flexible, and it provides you a larger zone of agreement between parties. So this is mostly because positional bargaining leads to a one-dimensional solution, whereas interest-based bargaining can lead to multi-aspect solutions, and that possibly satisfies more needs between both of the parties. So if that sort of elaborates on the whole interest and positional thing. Positional is sort of you're just sticking to what or where you're coming from, where you want to be, but interest is more of how you get there or how you get to the final position of both of the parties being happy. That's sort of why you have that broader zone of agreement when you talk about interest-based negotiation. Now, options, they're essentially solutions that satisfy most of the interests of the parties. You need to make sure that you try to be a little bit creative when you come to coming up with different solutions. And you should always try to make a very clear zone of possible agreement. So you need to make sure that every option is spoken about, is deliberated, make sure that both of the parties are happy with that option. Then you can say that, all right, this is a possibility, this is a route that we can take. Now, the third aspect is the standards. So this aspect determines what the points of comparison for a proposed option are. Now, standards could also be taken in as a reality testing method. So you basically look at whether or not the option that you have is something that can practically be used in the real world. That's what we call reality testing. And you can also use these standards as a way to say that, all right, as per industry standards, the solution will not work. Or you could also say that in the industry, commonly, these are the kinds of solutions that we look at, or these are the kinds of ways that we deal with a conflict. So that could be a way to sort of move forward. Sorry, there's a question from someone named Devyani Sahu. What if the agreement on which parties are agreeing upon is morally wrong? For example, in a matrimonial dispute, a woman agrees to sacrifice her job for her family's happiness. All right, so that's a pretty good question. It's important for you to remember that these mediations are completely confidential. So if, taking your example, a woman feels that it's her job to quit her, it's her responsibility to quit her job, then it's difficult for us to say that it is morally right or wrong. For us personally, in my opinion, I would say that it's morally wrong, but I wouldn't want to dictate what her morals and values are as a mediator. If she feels that that is what is morally how she wants to lead her life, then as a mediator, I'm in no position to say or judge her for those decisions. Can you illustrate reality testing with some kind of example? Sure. So a quick example. All right, let me just think for a second. All right, let's say that there is a dispute where you need to pay back some amount of money. Let's say that you do not have any cash right now and you are the debtor. The creditor is some kind of vendor that you owe because you're a manufacturer of let's say balls or something, just quick example. In order for you to pay back that debt, you need to have some kind of structure. So that is where reality testing comes in. You say that I'm going to pay this money, but the mediator says, but how are you going to pay that money given your current financial situation? Do you feel like that's something that you'd want to think about a little bit more just to ensure that the other party is satisfied with this whole promise that you're going to pay the money back? So at that point, you could say that let's put in some collateral and then structure an agreement saying that I'm going to pay back XYZ amount of money over this period of time, and after which you're going to return that collateral and you can collect some amount of percentage. So that is sort of a way where you check that realistically, is this a real solution to the problem at hand? Does that answer your questions, Devyani and Diksha? Okay, Devyani, I think, said thank you. Diksha said yes. Awesome. The next question is from someone named Mansi Tiwari. So it reads, if the case goes towards stalemate, even if we try to decipher an exquisite solution to the dispute, then what should be the change in our problem-solving methods, if any? Okay, so maybe Swinny could take this one for a second.
Sure. So normally when you have a complete block from the other party that they're not ready to accept any kind of solutions, you normally go into a caucus, and that's when the mediator's role becomes extremely important, that they're trying to understand that why is the party so reluctant to accept any kind of different solutions, and even try to look into it for that matter. So that's when you go into deeper understanding of the issue and understanding of why the party is saying no to any kind of solution. And then you go into caucus. Normally you can just have a private session with the mediator where you try to express your disappointment or pass on some confidential information to the mediator, which then the mediator can understand on how to ask the other party from a different perspective or a different kind of how to convey the same information in a way that the confidential information is not revealed. Or else, the other way to go about it is a lot of paraphrasing and rephrasing the question and trying to change your offers as much as possible. You never stick to one offer at a time and say that this will be accepted. You always try to accommodate somewhere here and there. It may not necessarily be bargaining that, oh, you say 500, I say 100, and then we come down to 250. It may not necessarily be that, but I say, okay, what if I come down to 400 rupees? And in turn, you can provide me with some other services to compensate for the 100 rupees loss, 100 rupees deduction, which I'm making. So that's the way how you set off different things and look at different interests and try to paraphrase and rephrase your questions and rephrase your offer and try to make sure that it is as acceptable to the other party. But if the other party is completely reluctant, then mostly you go through another session. So that's how it normally goes. You have to continuously keep changing your strategy. You cannot stick to one offer and one strategy. So that's, I hope that clears your question.
So there's another question from someone named Udit Goyal. He asks if we can explain the difference between interests and goals. And like I was saying, this is something that you will have this doubt for a very long time. But from what I have gathered over the last few years is that your interest is more about, let's say, you have a particular sum of money that you want to get from, let's say, the other party. But your goal would probably be to continue that relationship that you have with your vendor and make sure that apart from that amount of money, you can still go back to the person for business. So that could be exactly. So goals are a means to your interest. Or so essentially, you need to make sure that you're not allowing that kind of contradiction to happen. Like your goal is the end goal and your interest is what you're doing in order to achieve it. So I think so Srini has it a little opposite. I think the interest is the way to your goal. Exactly. So we will be covering it tomorrow with a lot of examples as well as with the problem that Srini has shared with you. But at the end of the day, your interest is, one part of your goal, which is the larger, on the larger scheme of things. Does that answer your question, Mudit? Even though that was a very poor answer, in my opinion. You're welcome. All right, so moving on, the fourth aspect would be your relationship. So it's really important to remember that in a mediation, unlike a negotiation or an arbitration or regular lawsuit, you are looking to maintain relationships with the other party. So discussing with each other exactly what kind of dynamic you guys have currently and what kind of dynamic you would like to end with is extremely important. Now, this aspect determines options, alternatives, and as the parties determine whether they are there to work together or whether they're not there. So this particular aspect usually should be dealt with early on in the mediation so that you can set the tone for the rest of the entire conversation. Communication, so we feel that it's important for you to focus on the 4 Ps when it comes to communication, which is place, platform, people, and process. So now by focusing on these 4 things, where you are, the platform of mediation that you're using to have this conversation, the parties involved, and the process will sort of help you determine the tone in which you evaluate different options, in which you evaluate your circumstances, and it helps you it sort of helps you ensure that the entire thing is a collaborative process and not some kind of adversarial process. Soumya, you can go ahead, unmute yourself, and turn
Yeah,
your
can
video
you?
on also if you can.
Okay, fine. So can you just repeat the 4 Ps? I missed it.
Oh yeah, sure. It's place, platform, people, and process.
All right, thank you.
No problem. So the next part is commitment. You need to make sure that people are aware of what they can say yes to and what they cannot say yes to. So you can't make false promises. Now, this can be used to overcome a trust impasse, as one party may offer something to make the other party realize that their commitment to the issue is real and that they do want to solve the entire conflict at hand. Essentially, you need to show that you've showed up in order to come to some kind of amicable solution, and you're not there just to waste anybody's time. And the seventh part is your alternatives. So, how can a party achieve their position outside negotiations? What would happen if the negotiation fails? The answer to these questions is basically your best and your worst alternatives. And it's only when the best alternative is not as good as something which can be achieved at the negotiation table, that's when the party decides to agree to mediate, unless it's mandated. So these are the seven aspects of mediation that you have to keep in mind. If you have any more questions, we'd love to take them. I know we're sort of crossing our time here, but we'd love to stay back, answer any questions you have, or just talk to you guys as well.
Yeah, I had a question. Am I audible?
Yeah, go ahead.
Yeah. So during the course of this meeting, I heard several things about theory with regards to ADR, like books available and all that. How important is it in terms of both competition and in terms of like career wise? Is theory that important, or like can you do it without reading all those things?
So I'll quickly answer this, and then I'll let Swinny answer it. I have not read a single book, no theory, other than whatever course material I was forced to read in my fourth year as part of a course. And by then, I had done and won a couple of ADR competitions. So, in my opinion, it's not very important, but it does help, especially when you go to European countries. I've noticed that they really, really appreciate you expressing that you have this particular knowledge. There's a particular book called Getting to Yes. So the words that are used in that book, if you use them while you're in your round, judges do pick up on that, and it does give you a lot of brownie points.
Thank you. Got it.
I might have a slightly different approach here.
Okay. Now, okay.
So I think it's up to you deciding how you feel it's best for you. I have read a few books, and also I guess no, I took the mediation course in during my exchange semester, and also we had a course in Nalsar itself. And I have read a couple of books, not books, though, at least researched on different aspects of mediation, and you attend different webinars here and there where you learn about a lot of things. And earlier, my approach used to be, oh my God, why do I need to learn about theory? I can just go in and start negotiating. But when I went to CDRC Vienna, I found that every feedback I got was extremely based on all the theory which was taught to us 3 days before that particular competition. They were continuously talking about information gathering, and they would break down my entire session into all these theory points, and they would tell me this is where I was right, this is what I did good, this is what I did bad. And as he said, Vivek said that European countries do have this particular approach. So I found that, oh my God, I do need to understand this theory properly and apply it properly in my future competitions. And after CDRC, I entered into another competition. I kept that in mind, all this theory, and I made sure that I'm trying to, stick to those processes, because they do help at the end of the day. There's some reason why they did write down all these books on mediation, even though they kind of say the same thing. There's some reason to it, and I think it is applicable somewhere or the other. If you don't need to actively apply it, but somehow or the other, you'll just find yourself passively using the same. And I used to go into practice sessions in our college thinking, oh, I'll go bargain like 500 to 250 and all of that. And I realized that's not the way to go about it. And that's when theory helped me out a little bit. But it's up to you and how you find the theory is helping you out. You may not necessarily have to read every book under the sun, but maybe this course might help you out to know a little bit of the theory, which you might definitely know. And the way we've composed it is something which we've learned from our competitions and feedback, which we have gotten over our years. So yeah, that's two different approaches for you. I hope you can make your own decision.
Okay, thank you. Thanks a lot.
So we have another question from Devyani. He wants to know what are the different career options in mediation? I think that's a great question. Obviously, you can be a mediator. So, on the face of it, that's, I guess, one thing everyone knows. But it's also really important for you to be a good counsel in a mediation process. There are a lot of different things that you can pick up on, not just the technical aspects, but also with regards to making sure that your client is heading in the right direction, keeping on track, making sure that you're negotiating in their best interest. All of these are different skills that you need to have as a lawyer. And it works very different in a mediation than it would in a regular negotiation. But that question, I feel, would be better answered by the experts that we've invited. So they actually have built solid careers in mediation, and I'm sure
All right, so I think we're done for the content today. Oh, I think somebody asked me a question. What are the books on mediation that a beginner should read? I think one of the most important books, as Vivek mentioned earlier, was Getting to Yes. And a sequel to that is Getting Past No. So I've read both of them, and I think they're pretty great. And you will see me using words from that book here and there and quoting it everywhere. But I think those are the very starter books which everybody has to read. Not has to, but everybody definitely reads before entering into ADR. That's one of the first books I was sent by my seniors before I went to any competition as well. We can make some more recommendations if you like on an email if that helps. All right.
on another note, I just wanted to make sure that everyone has been able to log into Lumos Learning, create their accounts. Swinny sent you, a lot of these instructions that you had to follow. Did anyone have any trouble? Because you will be using that to answer your questions for tonight's homework assignment, which is just a quick quiz on the talked about today. So if anyone has had trouble, then send us an email, anything. And if you have been able to create your account, then please turn your videos on so that I can take a picture and submit it to our team to show that.
Yeah, just everybody turn on your camera so we can take a group picture and then we can share it on LinkedIn and probably make some nice memories. All right, so we have two screens and we'll just wait.
Thank you, Afshan and Mudit. Everyone else, please come on.
Thank you everyone who's turning on their videos. This is great. Thank you so much.